I think we are live. We are live.
What's up?
Everything is working. Hello, people. We are, yes, we are live. Everything's working. So, as you've read, the reason why you're here, obviously, is because the judge has just ruled in the Rekieta case. Let me pull up the document so you guys can see what we're looking at. And it's not good for poor Nick.
No.
It looks pretty bad.
Yep.
Me and Uncivil are going to go through it. But before we get into the document, let's tell people how we got here, right? Let's tell people how we got here. So we have always said, we've always said that Nick's battle was an uphill battle, right?
Yes.
Because, for instance, with each one of the issues that he brought up for the motion to dismiss, it just didn't seem like it was going to work. The first one was the video, right? The video, the guy didn't look at the entire video or something like that. So we said that was a loser. The thing about the guns, right? He's saying the guns weren't part of the search. We thought that was a loser. And the rest of his arguments we thought were just nonsense. So our prediction going in was that all of this would be denied. No?
Yeah, it didn't really look good. I mean, even from the start, it didn't look good because the standards that you apply in a probable cause are very low. You're just trying to find reliable indicia that the evidence of the crime can be found in the place where it's located. And so that evidence doesn't have to be as thorough or as detailed or even as reliable as evidence that's used at trial. For example, you can use hearsay in a warrant where you can't use it at trial because of different standards. So right from the start, there was problems just because the standard is so low. It's really, really difficult to fail to meet that. And the idea of this Franks hearing was that the cop lied, and at least in the ones that I've seen that have been successful on a Franks, they tend to be shock the conscience kind of discrepancies. They don't tend to be like little details. They tend to be full fat, no nonsense, unambiguous contradictions that cry for desperate relief. It's the kind of thing that is more typical in a Franks.
Yeah.
So I didn't have a lot of high hopes for it, and it didn't work.
Yeah. Now, just for I like to be totally transparent. Again, Nick is both our friends. I've literally spoken to Nick. I've been speaking to Nick for the past couple of days. I reached out to him this morning and we talked. So, me and Nick are still cool. A lot of people, for some reason, are like snowflakes out there. Like, oh my God, you don't believe Nick is going to win, so he's going to be mad. Nick is he's a big boy. He knows that, when I tell you guys something, it's coming from my honest opinion. I tell Nick the same thing I'm telling you guys. So there's no bad blood that we say that we believe is not going to be successful. I've told Nick I don't think it's going to be successful. So, and that's just the way it is, right? So for those of you who believe that we're being so mean to Nick doesn't even think that. Nick doesn't. He'll sit there and argue with us these points. So just let everybody know. So it's like, he was talking to Nick. Yes, I was talking to Nick, but that hasn't changed. That hasn't changed my opinion on most of the things. But if something does change my opinion, I'll let you guys know. But right now, it just hasn't. Go ahead. You want to say something?
No, it's just what I do, and I certainly know that you do endeavor to try to get the law right and try to provide good quality legal analysis. So when we try to provide an opinion, it's because it's our best analysis of what's going on. And my friend Nate here has experience both as a police officer and as a prosecutor. So he has experience in this domain. So he has a pretty decent idea about what kind of warrants will be valid and not. So between us, you can think that we're trying to give you a pretty reliable opinion.
And not even to not, like, I don't, it's sad because, the only reason why I'm really even doing this or even getting into this analysis because Barnes challenged, remember he challenged us all, read the documents, do the analysis. And I'm just going to say it. Nothing he said worked. The judge destroyed everything. Matter of fact, none of his arguments were even there. So, I don't, again, it's sad because I personally want to focus in on the legal part of this.
Yeah.
But I just think sometimes, our legal analysis isn't going to change based on who the person is. If it did, then it wouldn't be legal analysis. It would be, I'd be trying to push a narrative.
And the other
So,
thing that we both commented on, and I definitely believe this is still true, it's like once the state passed the motion to dismiss, we're going to trial.
yeah, it's over.
Because there are no more preliminary moves here. You know, there are no more intermediary steps. It's like we're going to trial. And so the only thing left is can we get it on the calendar? And yeah.
Let me see. I don't know how to be cool with Nick considering his kids are affected by this. Yeah, but just because someone has a particular drug issue and their kids are affected doesn't mean you can't be someone's friend. Like I wouldn't leave someone at their lowest moment if I'm their friend. If I'm a friend, I'm trying to help you get out of that, help them get into rehab, help them, solve these issues. Just saying because of what this being alleged is so bad. I don't. If the argument is I shouldn't be his friend at his lowest point, then I was never his friend at all, right? Does that make sense?
Yeah, and I mean, I don't really know the details of what's going on in his home life for how it has or has not impacted with his children. That's just speculation. I like to stick to just the facts that I can know in terms of what the state is presenting or what the defense is presenting, and at least for the criminal case, things are looking pretty bad. We're looking at a fairly serious felony, assuming, of course, that the state doesn't change it to be even more serious based on the testing. So I don't know what time limits they have there in Minnesota, but at least in principle, they could amend these charges to bring additional charges based on the additional drugs they found and potentially even more serious charges than they brought initially, depending on the details. So there's the possibilities are only downhill.
Yeah. It's so let's go into the ruling and because we know you guys like the documents. So let's go into the documents and stop all the playing around.
Yeah.
Here we go. We're pulling up the docs. This is it. Omnibus. So this is the judge's ruling. The above. Now, just so everybody understands, there was one judge assigned the Nick's case. Nick asked for that judge to recuse herself. She recused. So there's another judge who is not involved with Nick's civil case. So now it's a totally different judge who's been on there since August 21st, 2024, and he's evaluating this. Defendant Nicholas Robert Rekieta appeared and was represented by Francis White, attorney at law, state of Minnesota, appeared through Kirsten Pierce and Jordan Engler, assistant Candy, Ojai County attorney. So that's where we're at. So go ahead, Kurt.
No, yeah, defendant's charged with 3 counts. Second-degree controlled substance, although as we pointed out before, that was kind of on the borderline. The threshold for second degree is 25 grams, and he was found with 26 grams and change, including packaging. So there's still the possibility that could be lowered down to third degree at some time, although there's also the possibility of additional second degree or other charges based on other drugs, so that might change in the future. Possession of firearm by an ineligible person. He had a gun, owned a gun at the same time he's a user, which is a gross misdemeanor, and child endangerment, which in this case was, I believe, just the mere fact that the children were present at a place in which drugs also were present. So the child endangerment was the very fact that children was there and not more. I make this point because obviously child endangerment comes in different degrees of concern, and at least in my mind, that would be on the lower end of the degrees of concern when you're talking about child endangerment.
Yeah, this is kind of just tangentially. Like he had the coke, he got the guns, you got kids there. It just all kind of wraps up together. But I want to make it very clear for all of you out there who may think that Nick is pretty much is done. Like we all said, if that search warrant is not tossed, he's done.
It's a 2-witness case for the state.
So
it's a 2-witness case. You call the cop to the stand and you say, "Were you there that day?" "You surely were." "Were you wearing a body cam?" "Yes, I was." "Great. Let's roll through that footage frame by frame and discuss all the things you saw and observed. Is this you holding the bag of the drugs?" "It sure is." "Thank you, officer." Second witness. "Hey, lab tech, did you do a test?" "I sure did." "What'd you find?" "They're drugs." "Great. No further witnesses." Anything beyond that is bonus.
Yeah.
So it's a 2-witness case, and then you throw in additional stuff if you have time.
Yeah, I think at this point, I think he's done. So we have the 3 main charges, and it doesn't look good. So the defendant seeks a Frank's hearing. and contest the seizure of the firearms, which we're going to go into. And the judge in this particular thing goes through all the evidence that was essentially found with Nick. So here are the fact findings. Should we read through the fact findings? Yeah.
Yeah.
Mm-hmm.
So these are findings of fact for the purposes of this ruling. So the judge is the fact finder on the issue of probable cause. For that purpose, of course, on the issue of liability, which is to say guilt, the finder of fact would be the jury. But these are findings of fact by the finder of fact, the judge. So these are facts now, for at least the purposes of this exercise.
Mm-hmm.
So on May 22nd, Quinn Pomplin of Candy, Ohio Sheriff submitted an application for the search warrant regarding the premises. The address subject to the search warrant was known to the deputy be defendant's residence. The search warrant was for controlled substances prohibited by law, paraphernalia commonly associated with sale or use, and items that show controlled substance use are not legal drug paraphernalia. The search warrant was signed by the district court. Great. Moving on.
Sorry. I got to move this up so people can see it.
No worries. The search warrant application states that on May 16th, Candy, Ohio County Sheriff Officer Dave Nestor received a report of possible child neglect and controlled substance involving the use of the defendant and his minor children.
Now, I think it's important that while Kurt is reading is understanding this, the judge is laying out all the evidence they have for probable cause.
Right.
So all of this is the probable cause. So this is going to be lengthy because they're saying this is what led to probable cause. So removing one of these things doesn't destroy your probable cause because you still have all this. So the judge is being very thorough in saying this is why we have probable cause for the search warrant.
Yeah, much like trial too. You don't. How much of the puzzle do you need before you can say guilty, for example? It's not 100%. Proof beyond a reasonable doubt isn't that. So it's like, well, how much of the picture do you need? And removing one piece doesn't necessarily throw you below the threshold. It's the very odd trial where there isn't some sort of evidence that goes the other way.
That's
right.
Yeah.
There's usually something that goes the other way. So removing one piece from the equation isn't enough, and it certainly isn't enough when you have probable cause as a low standard.
Yeah.
In this case, Deputy Pomplin reviewed social media videos. Deputy Pomplin notes the defendant's appearance in the videos changed from January to May. His changes in appearance are noted as common with controlled substance users. Deputy reviewed Aaron Imholt's social media videos. Imholt hosts his own social media video program in which he commits crimes while on air. From watching Imholt's videos, it's apparent that the defendant and Imholt previously had a friendship and had since had a falling out. That is definitely one way to describe it.
Yeah.
Imholt states in his videos that he recently experienced with cocaine and Molly, which is uppercase. I didn't know Molly got a proper name. I'm sure she'll be thrilled. On May the 22nd of 2024, Imholt uploaded a video where he spoke about defendant and insinuated that defendant was using controlled substance. During Imholt's May 22nd video, he referenced a video posted by defendant on May 21st. Imholt notes that white powdery substances can be seen on the defendant's nose during the defendant's May 21st, 2024 video. The nose was not made out of coal, nor was the nose red like Rudolph Red-Nosed Reindeer.
Yeah.
This was a white nose.
White,
not black, not red, white.
But also, too, just so everybody understands, the cops don't have to prove beyond a shadow of a doubt that there are drugs in that house. It's just, is it reasonable to suspect that a search would find that there would be drugs there, right? Based on the information we have, and that's what this is all alluding to. They don't have to say I have somebody who saw the coke and using the coke in the house. But it's better to have that. But now they're using all the circumstantial, because again, this is a circumstantial thing. Other circumstances that would allow someone to understand that they would find this contraband in his house. I'm talking about contraband. I'm talking like a cop now. Contraband.
Defendant's May 21st video was removed from the internet. Deputy Pomplin was able to review defendant's May 21st video. Defendant's May 21st video is 4 hours and 4 minutes in length. At approximately 2 hours and I don't know if that's 2 hours or 2 minutes. At 2:46, I'll just read as written. Defendant leaves the video to use the restroom. Upon return at approximately 2:40, so that's 2 hours 46, defendant appears with a white powdery substance on his nose. Defendant's demeanor is excited. At one point, closes one eye to be able to read the screen, rambles, and slurs his speech. We've seen the clips.
Yes.
Defendant Pomplin was previously a drug recognition evaluator based on Detective or Deputy Pomplin's training and experience, which are the magic words the cops love to use.
Yeah.
Defendant's behavior in the May 21st, 2024 video indicates a poly, which is multiple substance abuse, which may or may not be the only poly thing that Nick is familiar with.
Uh-oh.
Deputy Pomplin notes defendant's behavior is consistent with using both central nervous system stimulants and depressants. Deputy Pomplin's summaries of Imholt's May 22nd video and defendant's May 21st video are accurate. That's a conclusion of fact I'd just like to make clear once again for the record. The judge is saying the summary is accurate. That's a conclusion of fact. That's a fact now. Moving on. There is no indication that law enforcement viewed an altered or edited version of defendant's May 21st video, even if it was not the original.
So remember that was Nick's big argument. That it's not the original video. It's not the original video. The cop lied, and the new video has this, what is it, the watermark on it?
Yes, from backwards internet.
Yeah. But the judge is saying if the two videos are the same, it doesn't really matter. It doesn't really matter. So
on May the 23rd, law enforcement found Vala stuff, and I think we can skip this part because we know what they found. They found drugs and stuff and guns. We can skip the finer points of these details.
Look at all that stuff that they found.
They found stuff.
We're at V, W. All this stuff is chargeable stuff too. 14.
All right. The information contained within the search warrant was accurate and reliable for the reviewing judge. There were no clear false statements, significant material omissions, or material misrepresentations that cause the search warrant to be false, misleading, or in violation. Again, that is a finding of fact. All facts contained in the memorandum of the court are incorporated by reference as findings of fact. They are findings of fact. Thus, based on these facts, the defendant's motion to schedule an evidentiary hearing pursuant to Franks is denied. Defendant's motion to suppress the firearms and ammo is denied. All other omnibus issues not argued with particularity or otherwise specifically identified to the court, whether included in writing or notes or not, are denied. So anything you didn't bring up are waived.
Yeah.
You use it or you lose it. This should be a familiar phrase with anyone who watches my channel. Court administration shall settle a settlement conference, and the memorandum of court is incorporated by reference. So great.
Now, this court administration shall schedule a settlement conference. I think that's like you pretty much got no choice. You're pretty much screwed, right? It's just like all the evidence is in. We got all this. It's over. It's over. It's over.
Yeah,
it's over. But now, it's not. This is the conclusion. But let's get to why this action. So this is now. So now we have the conclusion. This is the conclusion. This is the probable cause. That's it. Now the judge is going to tell us why. So he's going to go through Nick's arguments.
You want me to keep reading?
I'm sorry. Defendant appeared at this omnibus hearing, charged with 3 counts. Defendant challenges the validity of the search warrant, which we all went over multiple times, and moves for a Franks hearing. Now, to get a Franks hearing, well, they'll talk about it. Defendant also challenges the seizure of firearms during the search warrant execution, which we all kept saying. Challenging the search warrant doesn't challenging the firearms for the search warrant didn't make sense, but he challenged it anyway. So, now let the judge tell him. Warrant challenges. Defendant argues that Deputy Poplin made false statements or recklessly disregarded the truth in the search warrant affidavit. Defendant points to the following in support of this contention. Now, this is Kandahokai County Health and Human Services. So I'm just going with child services for sure. I'm just saying child services, but that's what that is. Determined a report of possible child abuse did not fit the definition of abuse or neglect. M. Holt and defendant had no longer had an amicable relationship, and the defendant alleges Deputy Poplin watched defendant's YouTube video on a third-party YouTube channel. Now, those are the 3 things that Nick was challenging, right? 1, they listed out that the state said this report of child abuse didn't amount to child abuse, so he didn't tell the court that. So that's the reason why it should be thrown out. I meant the video stuff and the Imholt stuff that he was what do you say that Imholt was an evil person who wanted to screw Nick, and that should have been told to the judge. It wasn't told to the judge in a way that let the judge understand the nature of the relationship. Is that a pretty?
Yep.
So now we're not going to read this because this is all law, right? It's the Minnesota Constitution, the case law. So the judge is going through. Here's all the law to determine. This is how we're going to determine a Franks hearing. But we've already been through all that before. So if you watch the channel and watch all the rest of our next stuff, you automatically know to have a Franks hearing, you have to show some evidence that the cop intentionally lied and that type of stuff, which again the judge are going to. So here it is. First, go ahead.
Defendant first contends Deputy Pomplin did not state in the search warrant affidavit that Child Services determined on May the 20th that the report of possible child maltreatment involving defendant's children was found by Child Services to not meet the definition of child abuse. The information provided in the search warrant case background indicates Sergeant Dave Nestor received a report regarding possible child neglect and controlled substance use. The statement was used to provide background information to explain the origin of the investigation involving defendant. There's no mention in the affidavit about any investigation by Child Services, as Child Services determination and investigation is largely separate and held to a different legal standard than that of law enforcement.
Now, hold on. Stop there. I remember somebody saying that.
I think we both said that. There are different issues.
Yeah.
In different courts.
In different laws.
In different laws.
Right? So, yeah. So just because you don't have one doesn't mean So again, it's almost like we wrote this, right? It's almost like we wrote this. It's that precise, because when you're looking at these issues, it just made sense. Go ahead.
Well, this next sentence is definitely something I would have written. The crux of the warrant was not the allegation of child maltreatment. It simply provided the context for law enforcement to begin their investigation. And this goes to something I said on my channel before, where I said that this issue about Child Services is just too tangential from the principal issue. We're trying to search the house for drugs. The question that we're trying to solve in whether or not to issue the search warrant is, can we find drugs in the house? That's the thing we're trying to do.
Yeah.
So this issue relating to the child or child neglect is too tangential from that purpose, because whether it's true or not doesn't really do too much to change the calculus one way or another. So therefore, it's too tangential to be material to the issue, and therefore goes to the side, which is kind of what I said.
Exactly what you said.
The statements or lack thereof regarding Child Services is immaterial to the search warrant and therefore does not amount to deliberate falsehood, nor was it made with reckless disregard. In other words, no one cares.
Yeah.
Defendant next argues that Deputy Pomplin misrepresented the relationship between the defendant and Aaron. The affidavit states that throughout Imholt's video blogs, it's apparent that they and Rekieta were friends and may have recently had a falling out. Defendant asserts that Imholt and defendant's relationship had deteriorated beyond a mere falling out, and that by failing to include disparaging statements made by Imholt on his videos, Deputy Pomplin made a material misrepresentation in the affidavit. The affidavit further explains that Imholt posted a video on May 22nd, where he speaks about defendants and insinuate controlled substance use. However, defendant Pomplin also included information that Imholt admitted to recent controlled substance use, which is essential information for the reviewing judge to determine veracity.
I want to get this ready.
No worries. The case background provides sufficient information to provide context of the relationship, veracity of the statements, and provides accurate information about the video. The information provided by the deputy about defendant Imholt does not amount to misrepresentation. They have, in fact, had a falling out. It accurately describes the relationship and includes information necessary to determine the veracity of the statements. Importantly, the information within the videos is not the sole basis of the search warrant, and certain statements of drug use were corroborated by Deputy Pomplin's own observation. So, like, if he was the only thing, and you attack that, then you have a problem. But of course, anyone with their salt in a search warrant probably wants to get more than one thing.
And that's what we kept saying too. It's about the totality of the circumstances. Yeah. Even if you pull that one part out, you're still good.
Right.
So it just didn't make sense. Well, it made sense to challenge the three pieces that he challenged, but it doesn't change the needle. And on top of that, like they said, it was such a small piece to it when you look at everything.
Yeah. I mean, that's like the thing. Like, all of them are relatively small pieces, and fortunately, they have multiple of them. And any one piece is, which snowflake is responsible for the avalanche. It's kind of the thing you're in at the end. And so, yeah, you have a real problem trying to attack it. And even like if you can attack the pieces, the next part of it is that has to have been basically readily observable to the signing judge at the time, that he could have made that determination based on the information that was there or not, as the case has to be readily apparent. So
Now,
Yeah.
now, before we move on to the next issue with the video, I want to go through the Nick Rekieta.
You want to go through a learned attorney's opinion
Yeah.
about why the Frank's motion should not be granted?
So
Let's go watch a learned attorney's opinion about why the Frank's motion should not be granted.
So I'm gonna share this video.
Mm.
This is from Third World, and he put together this video of Nick essentially arguing against himself about the Frank's hearing. So check this out, because again, it seems like this is the judge. He actually agreed with Nick.
Yeah.
Poe 287, show the difference, fuckface. What is the difference between the videos? Well, one says backwards internet on it. There's the difference. That's the only difference that matters, because it's different. Objection! So Frank's challenge is just a challenge to any of those statements. It says they're a lie, and says that lie is material. Now, if they make some misrepresentation that has nothing to do with issuing the search warrant, then oh well. Hold it! That's not the question. The question is, why didn't the cop just not lie? So if you're stuck in the analysis of arguing over the quality of evidence, you're way in the wrong part of the trial. Objection! The idea is that alone, like they lied once, is not enough to overturn a warrant. They have to lie in material ways that are to the issuance of the warrant.
Right.
Well, and that's what Frank's challenge is for. Hold it! Well, one says backwards internet on it. There's the difference. Objection! But did it, if they change that, if they get rid of that line, does a search warrant still issue?
It does.
If so,
Objection!
You're not in the right spot. And I'm sorry that practicing lawyers have misled you into the wrong analysis by not being competent at what they talk about. But they have. They have misled you. They have let you down. They have done so to extract money from you.
We've misled you. We've let you down.
Well argued. Well argued.
Yeah. So Nick was arguing against himself with that one, but essentially that's what this judge is saying. This is it's even if it's true, it's just not material. So now let's get to.
And if you remove the thing, would it still issue? And if it is, meh.
Yeah,
it's like that's absolutely right.
What do we stop at? Defendant
Okay,
white powder on nose.
Yeah. Defendant's final claim is the deputy did not view the original video from the YouTube channel, but rather watched the video from a third-party channel that reposted the video and did not watch the video in the entirety. The search warrant affidavit states that Eurofant, the cop, was able to view the video, was taken off defendant's YouTube and Rumble social media sites. And as we were sort of commenting between ourselves earlier, when you read this and you say taken off, the video was taken off, you can read that one of two ways, right? You can read that as that the video he reviewed, he got from YouTube, or you could also read it as taken off, as that the defendant removed it from YouTube. So that sentence is being capable of being read two different ways, which is interesting. I don't think that's deliberate. It's just an interesting syntax thing. The deputy notes the defendant appears to be drinking an alcoholic beverage, and later in the video, defendant appears to have a white powder on his nose and behavior indicative of controlled substance. The case background states that the entire video is 4 hours and 4 minutes long, and approximately 2 hours and 46 minutes into the video, defendant leaves to use the restroom. When he returns at 2 hours and 50 minutes, he appears to be making an excited look and has a white powdery substance on his nose. The deputy Pomplin also notes that during the YouTube video, defendant has closed one eye to read the screen, ramble, and slur speech. These above timestamps described by the deputy are consistent with the video uploaded by the state. Based on the court's review of the video, the descriptions are accurate of the representation of the defendant during the video.
So essentially, the judge looked at the video with the watermark. Then he looked at the original video, looked at the timestamps, and said these things are identical. Right? These things are identical. There's no difference. Now, remember when we just watched, Nick was saying, "Well, it's different because it said backward internet on it."
And that was the only material that mattered.
That was different. Yeah.
But we're not buying it.
But as you can see, the judge is like, if they're exactly the same, it doesn't seem like it.
Yeah. It's unclear if the deputy viewed the video from defendant's YouTube channel or from a third party. And I think the reason is because that sentence is capable of being read two ways, as I pointed out. The state noted that the video from defendant's YouTube Channel was disclosed to defendant on July 3rd. Even if the video defendant was a copy taken from a third party, there's no suggestion that the content itself was doctored, clipped, altered, or otherwise changed. So it's digital. It's a copy. Yeah.
Yeah, that's it. And all the arguments about authentication and all that stuff, as you can see, they're out the window because this isn't a trial. When you're at trial, you have to authenticate stuff. You have to have witnesses come there.
Right.
This is not trial. This is pre-trial, and this is a search warrant. So at a search warrant, you can use hearsay, things that would never come in at trial, right?
Yeah, in a trial, you bring in the original. You get it from YouTube, and
yes. But here,
or his Rumble page, or wherever else you get it from, and call it a day.
Yeah, and you have to have it authenticated. But here, you don't have that. So let me see. The judge is a Kiwi farmer. You guys are crazy. Would we end that?
Okay, defendant also argues deputy did not watch the entire video and only watched a 1-minute clip contained in the PowerPoint, which also doesn't quite make sense because how did the clip get in the PowerPoint if not by it being clipped out by someone who watched it? But I digress.
Yeah.
The PowerPoint clip contained in the exhibit shows defendant's video is 4 hours, 4 minutes, and 4 seconds long, which is the same length. When the image is cross-referenced with the full video of Exhibit 10, the same image appears at the corresponding timestamp. Exhibit 4 is an image that's purposely taken from the clip of the PowerPoint. When the image in Exhibit 4 is cross-referenced to the full video, the same image appears. There's no evidence that the images of Exhibit 2 or 4 are an inaccurate description of the video. Most notably, the deputy asserts in the affidavit that he watched the entirety of the video that was disclosed. So you said he didn't watch it, but the deputy says he did. So,
and all the timestamps that the deputy points to are correct. All of them match up. Everything seems like he watched the video. So it's like all the evidence that the deputy provided seems to suggest he watched the entire video. And Nick says he didn't watch the entire video. How do you know? Well, you have to. I think the court is like, we got to go with the evidence we got, which seems like he watched it.
Do you have any evidence he didn't watch the entire video?
No.
Okay. Well, the cop says he did, and you don't have any evidence to the contrary, so I'm going to go with that for the moment. Because again, remember the standard here is really, really low. Yeah. It's basically prima facie. It's prima facie, basically civil. It's kind of at least comparable. It's like he says it's true. We'll take it on its representation. He swore it under oath and affidavit, so all right. The court does acknowledge that using social media as support for a warrant is somewhat unusual, and caution must be used to ensure that an altered video, parody, etc., are not used as support for a warrant. In this case, there's no indication the deputy did not watch the video, nor is there any evidence the video is altered, or parody, or otherwise inaccurate. I'm not sure the degree to which that statement though is true, that social media content is not used in warrants, because I would think that would become increasingly true
that we communicate over. But I'm thinking he's talking about like AI. That's the AI thing,
right?
Like, just in case maybe AI could be. So but here he's saying it was essentially they have Nick's original stream, they have this alleged the stream from the other place, and they just looked at them both and said they're exactly the same. So
there is insufficient evidence to show the deputy made statements or omissions that were false or reckless in disregard and material. Therefore, a Frank's hearing is not required. Go away.
So the Frank's hearing, as you remember, Nick arguing against Nick, the Frank's hearing is denied. There's no evidence. And again, the judge is saying all of that is good. So it seems like, so as at this point, everything that was found in that search of Nick's house is coming in the trial.
Yep.
All the drugs, all the stuff, all of that, the guns, all of that is coming in. Well, now we're going to talk about the seizure of the firearms. What about the firearms? Because don't forget, Nick was asking for firearms to be thrown out, and they'll tell you the reason.
You want to skip this because it's just like legal stuff?
The law, yeah.
Yeah. Okay.
Law enforcement had a vote. Oh, yeah, here it is. The search warrant provided. Search warrant provided described for under the general warrant officers. So yes, I think we should start there.
Law enforcement officers had a valid warrant to search for items of the kind described in the warrant, namely the drugs. Therefore, under general rules regarding permissible scope of valid premises for search warrants, officers are authorized to search all areas inside the residence where one would reasonably expect to find those items, including containers that could conceal the item. So you're allowed to look basically anywhere in which the item you're looking for might readily be found, which in the case of drugs is pretty much everywhere. It's all the places. So if you're searching for a stolen automobile, you can't go look in the guy's closet. The automobile will not be found there. But if you're searching for the drugs,
It's like if you're looking at stuff like this, you can open this up because you're looking for drugs, which can fit inside there.
Yeah.
So, but it also opens up the guns though, because if I'm looking for drugs and find guns there, well, it's all good.
Okay. During the course of searching for the items named in the warrant, firearms and ammo were discovered in areas where drugs could be kept. So they were searching for the drugs, and along the way, they found the other things.
Yeah.
The evidence of controlled substance use was also found during the execution of the search warrant, namely controlled substances and paraphernalia testing positive for controlled substances. So they did their, field test, which says, yes, drugs, which therefore allowed for immediate seizure and possession of firearms as evidence for possession of firearms by a user of a controlled substance. The seizure is lawful, therefore it is denied.
Now, I think the most important part is that that's exactly what we said all this time. This essentially what the judge is talking about, the plain view exception, right? I'm searching for drugs. I'm in there lawfully. I see the firearms. And I love the way the judge put it, because the judge made it very clear. Seizing the firearms in any other scenario, would be unlawful if you're looking for something else. But the fact you're looking for drugs, you found the drugs, you field tested them, it came out positive. Then what that does, that gives you probable cause to seize the guns, because now the guns are illegal.
Yeah.
Because you need probable cause to seize. You would need probable cause to make that seizure. And the probable cause you get to make that seizure is the fact that you have, again, tested drugs on scene. They've come up as cocaine, and now you have controlled substances with the guns. Guns are illegal. Let's take the guns. So it was, again, and myself and Uncivil and the other attorneys were all saying that this was it's simple. It was simple. But again, it just is what it is.
And then for the last sentence of this thing, for the probable cause challenge, defendant makes a vague passing reference to probable cause challenge of page 8. So this would be the idea, not that the detective lied, which we've been talking up to this second, but even assuming everything he said is true, there's still not enough there. That would be the probable cause. There's still not enough there. So court says you make a vague reference to that idea, but then you say the probable cause challenge is untimely, not proper noticed. In other words, go away. So you can't raise the issue that even assuming everything was true, it's not enough. You didn't give enough notice. It's now untimely. And so it goes away. So you've lost every possible basis to challenge the warrant. And so, yeah, that's it. That's the end of the game.
So now, let me take this down, because now we got to talk about just keeping it real. Where do you go from here for your neck? What's your legal out here?
So the best possible resolution is still some sort of diversion program, assuming one is available. The state's got this relatively cold. It's fundamentally a 2-witness case. You call the detective or the deputy. You call the deputy. You're like, you were there, right? Here's your body cam footage. Let's go through it. Is this you picking the baggie out of the safe? It surely is. Call the lab tech. It tests positive for drugs. How much did it weigh? The amount it weighed. Great. And then, if you have an additional witness that you can bring in, then that's fine. It was found in their house, so you've got constructive possession by anyone by Nick, and so they've got him basically dead to rights on it. So your best option really is to take a deal. I don't think the judge is wrong. The judge's findings of fact, obviously, are findings of fact, and you're not gonna overturn those on factual conclusions by the trial judge. You're not going to win on that basis. And as for the legal issues, I think that the judge is correct. And plus, you can't really appeal anyway, because because you can't appeal interlocutory. You can't appeal this while the case is ongoing, I don't think. So that means the only way you could appeal this is by going through and getting convicted and then appealing this as part of the conviction. I don't think you can appeal this in the interim. So, and I don't think it really works anyway. So your best option is to try to find a, diversionary program that gets you out of this, preferably with a misdemeanor or better would be nice.
I'm going to say Nick is proper effed. Nick, it's over. Yeah. This case essentially is over. I understand, and it's one of those weird things where it's hard to say, but this case is over. And every lawyer who is not insane has been telling you, if the search warrant is found to be good, if he can't get it bounced,
Yeah.
he's done. At the heart of this case, people, this is a simple possession case. We found drugs on you in your house or in your car. It could have been in your car, in your house, in your pocket. We found drugs on you. So unless the search was bad, then we can discipline. But because the search now is good, stone cold good, that the judge is saying, what do you got?
Yeah, and so like the only other thing you could try is trying to argue as a matter of fact they're not your drugs. And then of course you have to provide some evidence from somewhere they're someone else's drugs, which presumably means that you have to take the stand, because where else can that evidence come from? So the only other thing you can do is the Shaggy, it wasn't me.
Yeah.
But that, even if you want to try the Shaggy, it wasn't me, that's a trial issue. There's nothing left for the judge to do. The credibility of the witness is a matter for the jury.
You have YouTubers and celebrities falling from grace in more ways than one. Oh, well, things happen. Things happen, unfortunately. What was this one say? What's up? We're releasing the cop body cam footage. They're working on that. They're working on that. Kiwi Farms is all over that. If they haven't gotten it out yet, they are probably working on that every single day. I know that's Nate the lawyer. Yes, it's me, Nate the lawyer. But I will say this, though. I kind of feel vindicated by this whole thing because we were being called ridiculous, non-practicing. We don't know what we're talking about and all this other stuff. It's about like what Barnes was saying. Barnes was killing us, right? He's like, you guys are dumb. You guys don't know what you're talking about. And literally, this judge, it's like he watched our videos. He was like, hey, listen, what these guys are saying is exactly what the law is, and put it down on paper. And it one thing it does also shows you too, bad lawyering can really get you fucked up. Like if those were his arguments going into the First Amendment, First Amendment, Second Amendment, Third Amendment, Fourth Amendment, Fifth Amendment, even about quartering soldiers, right? Like even that's an issue. But none of that was even argued. None of that was even. Matter of fact, the judge rejected all of that in such a methodical way too. Do you see any way you can attack this on appeal? I'm asking you, just based on what you read.
No, the findings of facts are not attackable. They're not going to be clearer or anything like that. They're perfectly reasonable factual conclusions, and the law that follows from them seems sound. I don't see any basis to challenge this. I think the judge's note that you need to potentially review social media stuff with the note of caution is fine, but the judge says, well, even doing that and taking it with the note of caution, I've determined there's nothing here. It looks okay to me. Yeah. And anything beyond that, you're gonna have to take to trial. So yeah. So I don't think you can appeal this unless you're convicted. I don't see how you can appeal this in the interim. So yeah.
So now let's talk about the two co-defendants, right? Because you got three people. So this is Nick challenging it. So obviously, I think the issues would be the same for Kayla. Kayla,
right?
Because again, it would be all about Nick. So Kayla, I think, should be done.
Although Kayla hypothetically can make the probable cause challenge.
She can make the probable
cause challenge that Nick left behind, which is kind of hilarious. So if Kayla's lawyer is able to make a successful probable cause challenge, which seems unlikely, but at least it would be a point of differentiation. It could hypothetically mean that the charges get dismissed against Kayla without them getting dismissed against Nick, which is pretty hilarious. And then, of course, for April can only file this challenge if she lives there, because otherwise she doesn't have standing. I'm just visiting Nate for the day, right? So yeah. I don't live here. So if the police come bust down the door right now, Nate can challenge it for the search warrant, but I can't challenge the search warrant.
You don't live here.
Because I don't live here, so I have no standing to challenge the search warrant. But so April can only file a challenge if she lives there, which of course means that they'd have to admit to things that perhaps they're less happy to admit to, but we'll see how that goes.
Well, I think you have no choice. I think April, if she wants to get out of this, I think April's argument is a little different. I think her argument would be, if I'm April, I was just a visitor there. Those weren't my drugs. They were their drugs. They were in their room. Blah blah blah. I have nothing to do with that. That's the only way, because I think she can get around the constructive possession.
Sure.
And then that argument, right? But I think that's an argument.
It also helps a lot if she doesn't live there.
Yeah. But then,
because if she lives there, then arguably they have a constructive possession argument for her too.
But then in the catch-22.
Yeah.
The catch-22 is, if you don't live there, then you can't challenge on the Fourth Amendment because you got no right. It wasn't your house. Search and seizure, you're all. So they're going to have to pick a side. Does she live there so she can challenge the search, or does she not live there and she can deny constructive possession? It's a hell of a choice. It's a hell of a choice. And then also think about this: the conflict of interest here. Nick, and she's got to say they weren't my drugs. Who else's drugs could they
There's
be?
not a lot of possibilities.
There's
not a lot of other possibilities because, like, who else's could they be? And I saw someone in chat suggested that, Aaron as a possibility. But again, like, even if you wanted to go down that road, you still have to, like, present evidence at trial because that's a question of fact. It's like, okay, they're not my drugs. Whose drugs are they? So you have to present evidence that they're someone else's drugs. Well, how are you going to do that? How are you going to do that? You're going to take the stand yourself and say that there's someone else's drugs? I mean, okay, good luck with that, I guess. Try selling to the jury. Yeah, they're not my drugs, even though they're found in my house, in my bedroom, in my safe, and everything else. Try selling that to 12 people. Good luck.
This is the Hail Mary play here to try to blame it on the toe. They were his drugs, my honor. Oh, I'm assuming that may be. Would that even work? All right, so.
Yeah,
it all depends on when he was there, right? And then you're talking about having drugs in your house that you don't know about. Then you have to kind of show that it was not only his drugs, he left them there. That's a hard pill to swallow. It's going to be difficult, especially the fact that it looks like Nick was using drugs. So just imagine you being on the jury. Just imagine you guys being on the jury, and he comes in and says they were steel toe. He planted them there, but then you have you got the drug issues that, the kid being positive for cocaine, and all this other stuff. It's a hard sell to a jury, no?
It's pretty hard sell.
I think it's a hard sell, especially with white powder on your nose and the video. It's a hard sell. It's a hard freaking sell. And the fact that he wasn't there when the drugs were found, matter of fact, I don't think he'd been there for a little while. So if you're going to blame steel toe, you need more. Now I think they've discredited steel toe by Aaron.
Well, yeah, he discredited himself with the revenge porn thing. That didn't help.
Yeah, I think they discredited him, but I do think that at the end of the day, I don't think it's going to be. I don't think it can be successful unless you have more evidence. Now there could be some evidence out there that points to steel toe, bringing the drugs or something like that, or but it's going to be difficult because the drugs were found in your bedroom. So, on a count, right? It was on the bedroom, the counter with the credit cards on top of them. So are they going to be there for a week without, the last time he was there? I don't know. It's a hard sell, but maybe that's something. Maybe that's something that they'll be putting in. I've always said, if I have a tax issue, I'm contacting Barnes. Well, not unless you're Wesley Snipes. Wesley Snipes took some time on those misdemeanors, right? If I want to protect an intervention, I am reaching out to Kirk. Invention, I'm reaching out to Kirk. But if I'm caught with drugs, Nate, you'll get a phone call, even though I do not have your number right now. No. Well, Britt, you know how to contact me. You've been here a long time. You know what's up. So hey, if you need it, you know where I'm at. Thank you, Britt. Thanks for the super chat. Nick just needs to take him to the Supreme Court. They're going to laugh him out of the Supreme Court. They're taking his case. Come on.
I don't think they're going to take this one. I just don't see it. I don't think that's going to happen. Yeah.
Let me put a poll. Let me. Well, you know what? Because it's two chats, I'm not going to put a poll in the chat. I'm going to ask you guys so this is the question. Should Nick take a plea? 1 for yes, 2 for no. I believe he should take a plea. So I'm going to put a 1 because I think I don't think there's anything else you can possibly do. You have to it's a simple possession case. So 1, should he take a plea? 2 is no. And we're going to do this.
If he can get out of this with a misdemeanor with an eye towards dismissal, then that would be the dream. I mean, he does have no prior criminal offenses. I understand he has some traffic stuff, but that might not be criminal because of the way that different states classify it. It gets a little weird. It's not important. But anyway, so he might not have any criminal history, and even if they were criminal, they're like they're traffic things. I mean, come on. So he has no real criminal history worthy of speaking of. So, if he can get out of this with a misdemeanor, then he should probably take it and run.
Well, I'm thinking this. I'm thinking, as of right now, it's a loss. You're going to lose at trial. There's no, because again, it's like Kurt said, it's a very simple case. It's a possession case, so I don't think you have anything to worry about with, if you're
I've
prosecutor.
never prosecuted a case in my life, and I'd feel very comfortable prosecuting this case.
Yeah,
it's easy.
It's a simple.
I could do it in my sleep.
So with that being said, I think now you're looking for an out, and I think there's a couple of ways you can do it. One of the three parties can say those drugs were mine, right? I have an addiction, I have a problem, I want to go into treatment, and because we're the society, like Minnesota is very liberal. They would rather seek treatment for people who are drug abusers versus punishment. So you're looking to play on that. Hey, and you're looking for, and obviously first defense. And I want to be very clear, a couple of things, because when we say he's cooked, he is cooked for the felony, but he will do no jail time, even if he was, even if he was convicted on the top count, on all counts, he's likely not doing any jail time. He's probably going to get some type of probation, and that he'll have the felony on his record, and he won't be able to have the guns anymore.
Yeah.
But that's the thing that I think will that's the thing that I think is the most likely outcome, is that he'll probably, he's going to have to plead to something. But with that even being said, I think at the end of the day, I just don't look at all the ones in the chat. I just don't see any outs for Nick. I just don't. But there may be something else new, some new information that we haven't just heard, but it seems less likely. My favorite lawyer is keeping me company while I'm ironically doing my legal ethics work. All right, Sandra. Nick is too far in. Go for the touchdown. I don't know. Right now, the fat lady's warming up, and she goes on in 5. So it's crazy, because I think as of right now, Nick could save Kayla in April.
By falling on a sword, sure, big time.
Or one of them could fall on the sword. But I think April's in the worst position, because she's still staying there. She's still there with them or whatever. And now she's adverse to them.
Yeah.
Because she's going to be in that court saying, those aren't my drugs. And Nick's going to be in that courtroom likely saying these aren't his drugs either. If he says they're his drugs, he might as well just plead to the top count. So that's got to be an awkward situation to be in, right? It's got to be, unless like somebody chatted earlier, they say it's errands, but then you got to show some evidence that they're errands. The only way it can get worse for Nick, if his next motion cites the UCC and the judge's oath, Magna Carta. You guys are cold. Will he be disbarred for being a felon?
Probably not.
Yeah, he's not. He won't be the first lawyer to have cocaine who used illegal drugs.
It's been known to happen.
Yeah. But I don't think he'll be. I think the felon. Well, if they give him the plea to a felony, I think that's hard. That's a horror show, because a felony conviction gets you so much. You know what I'm saying? It gets you so much. Yeah, because the thing that gets you real hurt with the felony is literally the fact that you can't have the guns, all those guns and stuff, and he likes to shoot. That fucks you with that. So I think that
if he's looking to get rid of him in a hurry, I'm willing to take possession of him as a friend.
Yeah, but so that is going to be that I think is going to be the tough part, or whatever. But again, like I keep saying, you guys have seen all of the different lawyers go through this case, go through the evidence, go through the facts, right? Say their opinions, predict what's going to happen. And, some of us happen to be right. Some of us happen to be right on point with exactly what we're saying. And some of us were wrong. And here it is. It should behoove Nick to start going to NA meetings now, if he wasn't already doing so, already done so. Yes, he should. He should definitely. And I will also say the reason why I do feel vindicated, because I hate being called, dummy, corrupt. My analysis is bad. I don't know what I'm talking about. I should get a real legal job. And now the person who was saying all that is looking like the dummy. Their whole analysis was wrong, right? Their whole entire, matter of fact, the judge threw it all out and said it's garbage. So, I think when people start looking for, there are some political analysis that people should go to, right? Politics, right? People will do politics. When you come to legal analysis, you should start looking at who's getting it right and who's getting it wrong, or at least who's giving you the fair analysis. Because again, like we were both saying, we don't know if the judge was going to deny all this. But if I was a judge, I would deny it. But we'll see what happens, right? And it's a fair assessment. There are other people saying that the judge is going to straight up grant the Frank's hearing.
No.
But as you can see, there was no Frank's hearing. There isn't going to be no Frank's hearing.
I thought it was pretty weak sauce, and so I'm feeling a little bit vindicated myself because it's like, yeah, I thought this was pretty weak, and the judge seems to agree with me. It's pretty weak. So
yeah, we always say
Yep.
that. We always say that. We were being called idiots and fools and not understanding the law and being so. It's like no. We understood it. It was the person who was saying that. Like I kept saying, I wrote search warrants. I defended search warrants. And when I saw this, you said, matter of fact, you were like, the search warrant is unattackable. That's what you said. You said, it's unattackable. It's gonna hold up. And then guess what? It held up as essentially unattackable.
I did say that.
That was your exact word.
I did say that because I'm like, well, I can't find it.
I reviewed Minnesota's disbarment each year. I think is it each year? Last few years, every convicted drug felon has only been suspended. Yeah,
that sounds very plausible.
That makes sense. That makes sense.
That sounds right.
That makes sense. But right now,
so we're going to trial in January or something, I guess.
Well, right now there's going to be a settlement conference.
Yeah, that's what they say. Could be a very short one.
And I'm telling you, if the settlement conference, see, court administration shows a settlement conference. What they're saying is, you know what the DA is going to go in there and be like, unless the next word out your mouth is "I'm guilty" and looking for a deal, there's nothing to settle.
Yeah.
Matter of fact, if you're the DA, would you take a plea? Would you like they got all the cards now? And this is another reason why. Again, this is from a former prosecutor. If you ever get arrested, there are stages in the trial where the offers from the district attorney's office are going to be definitely better than later on. So, for instance, when I was at the DA's office, we used to talk about pre-indictment offers. So that's when you first get arrested. We're not too sure what the facts are. Cops say this, and and then you get an offer. And the offer, like in this case, the offer would have been, again, I don't know. I want to make it very clear. I don't know what the offer was in this case, but an offer generally in this case like this, first time offender, lawyer, this, you would be looking maybe at a misdemeanor, go to rehab, or that would be like the original offer. It'd be a very good offer. Matter of fact, I'll tell you about a case that I had. I had a case where the person was arrested for doing unthinkable things to a child. Unfortunately, the person was doing unthinkable things to a child, and my client wanted to go to trial. I didn't do it. Now, the evidence against this person was overwhelming. I'm talking about video evidence. Blah, blah, blah. It was overwhelming. He sat down, and on top of that, he gave statements to the cops, told the cops the whole story, right? Gave the cops the statements.
Good.
And the statements were so bad for my client, right? Because usually you don't talk to the cops, but he went and gave up all his right to talk to the cops. His statements were so bad that he would put something like at 5:03, I was walking down the street. At 5:07, I went to the store, literally. And the cop, after they let him write that whole two-page crap, they asked him, well, how did you know the time so precisely? And he said, oh, because I was looking at my watch every couple of minutes. And then they said, where's your watch? Oh, I lost it. That's how bad it was for this guy. So the first offer was 2 years, suspended sentence, and you plead guilty and you'll be on the sex offender registry, right? Okay. No, he didn't take that. So then then he got indicted. Next plea was, okay, we'll give you 4 years now, because now you made us indict you 4 years. And you'll do one inside and go to a treatment program and then be out. Okay. Rejected. The eve of fucking trial. We're about to literally go to trial. And the DA sends up, because we have all the, we sit down with the client, we say, here is all the evidence, right? This is it. We can't put you on the stand because you're a freaking liar, and it's gonna be a horror show. Do you want to say yes? Because he could have gotten 30 years in prison. Went to the DA, EVA trial. What can you do for us? The guy did 10 years. So we went from 2 years suspended sentence to a 10 years in jail. That's the hell.
That's a very big difference between those two numbers.
And he ended up to blame me. And I'm like, you should have pled guilty earlier. They got you on tape. It's ridiculous. But that's the difference between when you plead. So that's why I'm thinking for Nick, the earlier you can get, and again, there's this whole, I'm sorry, blah, blah, blah. And my case was bad. Trust me. The first plea bargain, I was the greatest attorney on the planet because I was begging for him to take that. But he got 10 years. And the 10 years, to be fair, that was even a deal because he was looking at 30. He was looking at 30. 30 without the possibility, and it was the way it was, which is insane. So the law was you would do your 20 years, and then you have to go to parole board, and if they let you, they maybe let you out. But who's going to let out somebody who's done this and blah,
probably
blah, blah.
not doing good, great, yeah.
Yeah, so he was looking at some serious time. But again, so he did the 10 years, but we got 10 years and out. So he did 10 years and got out. But even without all that, I think now it's the time to go to the DA, and I think each side now. I'm assuming because I saw what's her name, April. She has her omnibus hearing coming up soon.
Mm-hmm.
So
that should be entertaining. See what she files. See which way she wants to jump.
Yeah, but I and it's probably going to be in front of this same judge or similar judge.
I would think so.
So I want to see what her motion is going to be. I think it's October. But I think if she uses any of these arguments, and she lost her first argument because she was saying it wasn't constructive, like the drugs weren't hers, but they were like it's. But the fact that her credit cards were on top of the cocaine got her caught up. So, but we'll see. So at the end of the day, what do you think should happen? What do you think should happen with this case? Because this is just like any other case we're looking at, except if it wasn't Nick, I think it would be less emotional. But what do you think about the end of this case?
I think there's only one girl I know who always tells the truth because she don't lie. She don't lie. She don't lie. Cocaine. I think it's not going great.
Yeah. So right now, my advice would be to plead out, get some help, and hopefully get a conditional discharge and go on home. Right?
Yeah.
That would probably save Kayla. That would probably save April, and then you don't have anything to worry about. But but again, I could be totally wrong, and they can have some strategy that changes the game because who knows? But that's where I'm at right now. This motion being denied, I think, destroys his whole case. Nick has screwed himself and his harem so far by trying to fight this case and trying to keep his e-fame intact rather than just pleading guilty. It could be. I think at the end of the day, you got to know. You got to know. What is that thumbnail? To click the video. I'm not sure if that's mine or yours. I think that might be yours with him licking the ear. No, see, Nick needs to arrest the judge. But now remember, the first judge was the one that everybody was saying was the judge that was compromised, that ruled against him before. So that judge is not the judge that made this ruling. This is a whole separate judge who I think methodically went through this case and showed.
And also, it's worthy knowing, of course, that the state has to be willing to plead. And some of the things that Nick has said after being arrested have insinuated, at least, or could be interpreted as insinuating, that the police were dirty or acting incorruptly or even brought the drugs into the house. And so Nick has said some things that might not necessarily endear him to the finer points of the grace of the district attorney of Candy, Ohio County. So with that being noted, he should probably get on his knees and beg for mercy and see what he can get.
Oh, but this Piddle says I you're telling me I know, right? I know. Don't get me wrong. Sometimes we hold out and it works out, right? I have held out. Like the case I was So my defendant for the New York Times, we held out and we got it dismissed. So that was good because but then we had good facts on our side. And that they were playing hardball, but we held out and we got it. So.
I do not recommend the choice of take the stand and say it was really Aaron's drugs the whole time. That doesn't seem like necessarily the wisest course of action.
Yeah, but how to get to your bedroom?
Yeah.
Or then they find some stuff in the safe. How to get to your safe? It's you have so much. But again, you're trying to do reasonable doubt. You're not trying to prove it. You're trying to do reasonable doubt. So is it reasonable doubt is yours? But then you're gonna have the issue with the church people coming on saying he looked like he was strung out and blah, blah, blah. So then you got a drug user with drugs in the house, but they're not using those drugs. Does that even make sense? Yeah, I don't think so. I don't think so. But yeah, potentially criminal. I feel your pain. I feel your pain. Because you make sure you tell people if we get this done early, they don't know enough, and they give you the best deal. So, a matter of fact, there was another one. I'm not even going to go into the other one, but there's like so many cases that I can tell you where it's the deal started off amazing, and then next thing you know, went to hell when they got more information. But that's the justice system. So, well, listen, guys, you got any final thoughts on this, or what's up?
No, I mean it's pretty much over. Kayla will file the same argument, assuming it's heard by the same judge. Will come out the exact same way. I mean, she could technically argue the probable cause thing, but I don't think that works. I think same thing for April. Of course, she has to choose which way to jump. Really, there's nothing left to be done here except to go to trial, except to try to seek if you can find a plea deal. So, I don't know how Nick is going to interpret this, but I don't really see any outs, man, because it's a simple case to prove. I could do it in my sleep, and you're in a lot of trouble because they've got you on some version of possession, depending on the exact weight as it turned out, and because they had the presumptive weight from the warrant, remember, but the exact weight as it determines for the legal purposes, exactly how that's calculated with the packaging and all once it was taken to the lab. So, whatever that number is, that's the number, and what are you going to do?
This is why is it any of the government's business how much coke you featured?
Good question.
Robert Ball.
I don't necessarily recommend that course of argument either with the courts. That doesn't seem like that's going to work.
I don't think that works. I don't think that works. This Nick will never. At some point, it'll be dumb not to.
If he can get a misdemeanor with a conditional discharge, he should take it and run.
Listen, people, but it clears up. It clears up the wife. It clears up the April, which she is the mistress, or she may not be the mistress. It gets them off the hook. So at a point in time, you get to the point where do you really, you know what I mean? It's like somebody's got to. It's like we used to have cases where they they pull over a car. There's a gun in the car or drugs in the car, and nobody cops to it. So you charge all three. And then somebody eventually says, okay, it was mine. And the other two are let go, right? Because, again, it's constructive possession. And I think that's essentially the same exact scenario you got here. 3 people caught with these drugs. And until one person cops it and says they were mine, these other people weren't involved. They're mine and they didn't know or whatever. They got 3 cases. Because even if the government wants to continue on with the case against Kayla and April, and Nick, the cops, he can go testify in their case. It was totally mine. She had nothing to do with it. That's your reasonable doubt. You can't get a conviction off that. Same thing with April. She was a guest. It was my drugs. Sorry, I took a credit card and I didn't even know I was using them to cut it up. I didn't even you can get them out easy. But I think at this point, it's about this, right? It's about what do you want to do? Do you really want everybody? You got 5 kids. There's a lot of stuff you got to start thinking about now. He can just go to trial. And Darnell Brooks. Yeah, but it's not only him going to trial. He's going to trial. His wife's going to trial. And April's going to trial.
Everyone gets a trial, man.
Yeah. Nick is getting 20 years. Would be my 5K gift. Nah. I don't think he gets 20 years.
It's been a while since I looked at the sentencing guidelines, but as I vaguely recall, I think for a first-time offender, it's 4 years suspended.
Yeah.
Well, as memory serves, there is no presumptive jail time for this offense. So, yeah.
And one thing I also need to mention to everybody, because I think this is very important. These charges could easily expand.
They could do that too. Yeah, that's why I was saying earlier, because the state did their test and they found that were ketamine, or they found whatever it is. So it's like, will they bring additional charges? is there enough to even elevate these charges to a higher degree?
Yeah, because you got cocaine, you got ketamine, you had some of them, the brown powder, you got what is it called? Yeah, green colored tablets tested positive for ketamine. So this could expand tremendously. This could expand.
It could get worse.
Yeah. So that's what I'm saying. A plea now is without them loading you up with charges, because they could technically load you up for the ketamine and stuff like that. And now you're in a worse position, right? Because now your plea bargain becomes a lot different. So here is, but it is known Nick is diagnosed with oppositional defiance disorder. He'll somehow double down against any authority figure. I know. I have ODD too.
That will not end well.
No, it's not going to end well. What if Nick does coke and gets arrested on bail? Well, then he goes to jail. He goes to jail.
Yep.
And it probably sucks too, because you probably won't be able to drink alcohol and stuff for the 4 years you're doing a probation and stuff. So that kills the drinking streams. But yeah, but listen, this anybody who tells you this is not a big deal is lying to you.
It's a pretty notable deal.
If anybody sits there and tries to tell you this case isn't effectively over right now, they don't know what they're talking about. They don't know what they're talking about.
This case is all over. This case is over. Only thing that's left is plea or get convicted.
Yeah, that's it. That's it. Either George's going to tell you or you're going to cop to it. And I'm thinking they love your thunder. Yeah, I think it's over. I think it's over. So with that said, thank you guys for all watching us go over this thing. We'll follow the April when she files her omnibus motion. She's hoping to get it out, but I think the simplest way for everybody to just get out of this, one person pleads to it was all mine, everybody else gets let go, and then you move on with your life. Nick or whoever should go and throw themselves, hey, I'm going to treatment, I'm doing this, I'm doing it. It's going to be hard to have the government over your life for that particular time, but I think he can do it, and I think it'll be best for him and his family. But those are my final thoughts. So with that being said, you want to say anything before we get out of here?
Good. Love you all.
Thank you guys for watching. We'll see you later.
Bye.
Peace. Ending stream.